Hello everyone, and this is the video of Legal Studies Class 12 Unit 5, the legal profession in India, and we are dealing with the chapter that is the Constitution, its powers and functions of the State Bar Council. The State Bar Councils are the statutory bodies which are established under the Section 3 of the Advocates Act 1961. These were set up with different councils for the different states and the union territories of India. The council act as the regulatory bodies making rules for the legal profession and education in the respective states, and they also act as the representatives of the advocates of the state, thereby acting in the interests. Section 6 of the Advocates Act 1961, it also lays out the functions to be performed by the state councils in the respective states. They work in the coordination with and under the supervision of the Bar Council of India, which is the national body established under the Section 4 of the Advocates Act 1961. Furthermore, the State Bar Councils, they are usually known by the respective states or the union territories name, that is, for example, Bar Council of Delhi, Bar Council of Madhya Pradesh, Bar Council of Himachal Pradesh, etc. etc. But some of the names are clubbed with the other states and the union territories, such as for the state of Kerala and the union territory of Lakshadweep to be known as the Bar Council of Kerala. For the state of Tamil Nadu and union territory of Pondicherry to be known as the Bar Council of Madras. Just remember, for the states of Maharashtra and Goa and the union territories of Dadra and Nagar Haveli and Daman and Diu to be known as the Bar Council of Maharashtra and Goa. For the states of Punjab and Haryana and the Union Territory of Chandigarh to be known as the Bar Council of Punjab and Haryana. For the state of West Bengal and the Union Territory of Andaman and Nicobar Islands to be known as the Bar Council of West Bengal. Now we'll move forward with the functions of the State Bar Council. As per Section 6 of Advocates Act, the State Bar Council has the following functions. The first function is to admit the persons as advocates on its roll. Second is to prepare and maintain such rule. The third is to entertain and determine the cases of the misconduct against advocates on its role. Fourth is to safeguard the rights, privileges and interests of the advocates on its role. Next comes is to promote the growth of bar associations for the purpose of the effective implementations of the welfare schemes, to promote and support the law reform, to conduct the seminars and organize talks on legal topics by eminent jurists and publish journals and papers of the legal interest, to organize legal aid to the poor in the prescribed manner, to manage and invest the funds of the Bar Council, to provide for the election of its members, to visit and inspect the universities in accordance with the directions, to perform all of the functions which are conferred on it by or under this act, and the last is to do all other things which are necessary for discharging the aforesaid functions. Now we saw the functions, now we'll move forward with the power of the State Bar Council. Following are the major powers of the State Bar Council. The first is power to make rule. The State Bar Council has been empowered to make rules to carry on to the purpose of Section 16 to Section 27 of the Advocates Act 1961 dealing with the admission and enrollment of the advocate. Second is power to punish the advocate. See, advocates also get the punishment. So, the State Bar Council has the power to punish an advocate for the professional misconduct and the other misconduct. The disciplinary committee of the State Bar Council may make any of the following orders. Now, which are the orders? First is dismiss the complaint or where the proceedings were initiated at the instance of the State Bar Council, direct that proceedings to be filed. Second is reprimand the advocate. Third is the suspend the advocate from practice for such period as it may deem fit. And the fourth is remove the name of the advocate from the state roll of advocates. Now we'll move towards qualification to be an advocate. In order to be eligible for the enrollment according to Section 24 of the Advocates Act, an advocate must be a citizen of India, at least 21 years of age, must have an LLB degree from the Indian University, and he has paid in respect of the enrollment stamp duty and the enrollment fee which is payable at the State Bar Council. A foreign national may be enrolled on the reciprocal basis with the country of his citizenship, and his foreign degree may be recognized by the Council for the purpose. In absence of such reciprocity, foreign nationals cannot practice law in India. They cannot practice. Foreign nationals cannot practice law in India. Now we'll move forward towards the professional duties and the ethics of an advocate. The Bar Council of India rules encompasses the professional standards for lawyers as laid down by the Bar Council. The key duties and the responsibilities of an advocate can be summarized as follows. See over here. As an advocate, it has a duty to act in the dignified manner, to respect the court of law, not to communicate with judge in private and impair partiality, not to act in an illegal manner towards the opposition, and to refuse to represent clients who insist on adopting the unfair means. In addition, being an officer of the court, an advocate is expected to uphold and maintain the values of the profession. Furthermore, an advocate's duty towards the client includes bound to accept briefs, not to withdraw from service, not to appear in matters where he or she is a witness, not to suppress material or evidence, need to maintain the client confidentiality, and not to instigate litigation or to charge the contingency fee, that is fee depending on successes or favorable results of the matters. Next is duty to ensure that his or her duties do not conflict with the client's interest, and lastly, not to negotiate directly with the opposing party, only through the opposing advocate, and to carry out the legitimate promises which are made. Now, moreover, breach of these rules and standards of the conduct, it leads to the disciplinary actions against advocate which may result in the suspension or debarment. Remember, whatever the rules, the ethics, whatever have been discussed, just remember. Next is the advertising by lawyers. Advertising by lawyers, it's an interesting topic as the right of advocates to advertise their services or solicit clients has always been the controversial issue in the field of legal ethics and professionalism. In India, advertising by lawyers has been strictly restricted by Bar Council of India. An advocate is prohibited from promoting himself through circulars, through advertisements, through touts, through personal communications, through interviews, other than through personal relations, furnishing or inspiring newspapers, comments, or producing his photographs to be published in connection with cases in which he has been engaged or concerned. However, an amendment to this rule allows advocates to furnish certain information on their websites after intimating and taking approval for the Bar Council of India, and likewise only 5 pieces of information can be put up on the internet, that is, the name of the advocate of the firm, the contact details, details of the enrollment with the bar, his profession and academic qualification, and the areas of practice. Now moving towards advertising by lawyers in the United States. Till now we saw about India, now moving forward with the United States. However, different countries across the world allow the advertising by lawyers to varying degrees. The positions in the USA is different from that in India, where lawyers have the right to advertise but subject to reasonable restrictions. There were different rules of professional ethics for the different states, and there is also the model rules of professional conduct which serve as an indicative reference point. Rule 7.1 of the model rules prohibits false and misleading communication about the services. Rule 7.2 addresses advertising and referrals, and Rule 7.3 articulates no solicitation periods. Lawyers in the US can provide information about the class actions. They can approach clients by handing out the business cards and can advertise on the internet forums. For class action, solicitation through referrals is permissible. Newspapers and magazine ads and even mass emails are permitted as long as they are not misleading. And no financial incentive is promised. Personal injury ads are commonplace in the USA, often known as the ambulance chasers. These personal injury lawyers are robust. And in their advertising on billboards, newspaper, flyers, and even distasteful ads on the television. However, ambulance chasing is not the representative of the professional practice in India, since these class of lawyers, they are the sort who solicit business by littering around the hospitals or by ads in the newspapers and in the yellow pages with toll-free numbers and free consultations. However, it is a matter of debate whether the Victorian tradition, UK has itself done away with the prohibition, should be retained, within which law was considered to be the noble profession, and hence advertising was prohibited so as to not tarnish the image of the lawyers. The issue of the allowing advertising and solicitation by lawyers It requires balancing the interest of the public, which includes getting information on legal rights and services through advertisements and enhancement of access to justice and the legal profession on one hand, and the possible misuse of advertising techniques by lawyers, which may lead to loss of creditability of the professions as a whole. Moreover, countries like USA, UK and France, they are more flexible with granting permission for legal ads, and whereas Hong Kong, Singapore and Malaysia are moving towards progressive relaxation. In Malaysia, for example, the Legal Profession Publicity Rules 2001 is a simple, comprehensive code that regulates ads in legal and non-legal directories, controls publication of journals, magazines, brochures and newsletters and interviews in the media bars, publicity through clients, and even regulating the greeting cards. In Hong Kong, lawyers are forbidden to advertise on the television, radio, in the cinemas, but they are permitted to advertise in the print media. So this is all about the advertisement about the lawyers. I hope you all must be clear with whatever we have discussed in today's video. If you have any doubt, any query, do comment in the comment box given below. Take care and stay safe. Thank you.